And joining us today for the Institute of Justice, Christie Hebert and Jeff Rowes. Good afternoon, folks.
Good afternoon.
Good afternoon.
Good to have you with us today. Now, tell us a little bit about the Institute for Justice.
Sure. The Institute for Justice is a national public interest law firm, and we represent people for free across the country in strategic constitutional cases that are designed not just to protect the rights of our clients, but to set legal precedent that protects American liberty everywhere.
So you are representing the Warming Center.
Yes, we are. And we're representing the Warming Center for free.
For free?
That's right.
Okay, so this isn't going to cost the Warming Center a dime.
No.
Nope.
All right. Now, Christie, I'm sorry. Okay. Christie, tell me what you're going to do here.
Well, we filed a federal lawsuit against the city of Kalispell on behalf of the Warming Center. That lawsuit is now pending in the United States District Court for Montana, and it will be heard out of the closest federal courthouse, which is in Missoula. So we've sued the city of Kalispell for a variety of constitutional violations under the United States Constitution and the Montana Constitution.
This sounds pretty serious.
It is. We're making a federal case out of it. And if the city of Kalispell hadn't revoked their permit in a way that was completely unconstitutional and completely unjustified, we wouldn't be here.
So earlier we had talked with a city council member, Ryan Hunter, and he had indicated that he thought pretty much what you guys are saying, that once you issue a conditional use permit, you can't take it back. Is that our point here?
That's right. It's what's known as a vested property interest. Once the city issued the permit, the Flathead Warming Center had a right to use its property as a homeless shelter. And that's the same as if a permit was issued to a conditional use permit was issued to any other property owner. The city can't retroactively come back and say, oh, we're taking it back.
So, for example, I give you a conditional use permit to put a third story on a building.
That's right. They can't 4 years later come back and say, oh, we're taking it back. You have to knock down that third story.
Right. Yeah, you can basically, a conditional use permit is a big deal because people rely on it. People invest money, they change their lives, they open businesses, and the city doesn't get to just have buyer's remorse. We don't like this anymore, so go away.
So essentially all the arguments that have been presented here so far about pulling the conditional use permit, and that was the first thing that was brought up in the city council meeting. The council president, Chad Graham, that was the first thing he said, we're going to revoke the permit.
That's right. Back in April 2024, he basically said, that's what we're out here to do. And then they created a roadmap to do that. It's important to note that in Kalispell's ordinances, there's no process at all for revoking a conditional use permit. The idea there is that the permit is permanent. And there's no process for them to take it back. There's also no process under Montana law for straight up revoking a permit like that. Instead, Kalispell's ordinances say if there's a problem, if there's a violation of the permit, the zoning administrator enforces that like any other zoning violation by issuing a citation.
Was a citation issued?
No. The Warming Center has never gotten a citation. It hasn't broken the law. It hasn't violated its conditions. And in any other normal city across the United States, when a property owner isn't breaking the law, you don't make them stop what they're doing. And that's why the city of Kalispell had to dig deep and come up with some kind of crazy justification for revoking the permit.
What was that justification?
The justification is the idea that Tanya, in applying for the permit back in 2020, made misrepresentations or untruths. And the things that were pointed to are things like Tanya's representation that she was going to provide her cell phone to folks, to the neighbors. And she did. She provided her cell phone to the immediate surrounding neighbors. But the city council now 4 years later is coming back and saying, well, when you said that, you really should have provided your cell phone to people at an undetermined radius throughout the community so that they could have called you at any time about any complaint about a potential homeless person doing something potentially wrong.
Right. Like maybe 1,000 people might live within that radius. You're going to give your personal cell phone to 1,000 people and be on call 24 hours a day for whatever, grievance comes up. But, there was absolutely no misrepresentation. And in any case, the fact that the city is having to do this, to look at an application from 4 years ago and to try to gin up some mischaracterization as dishonesty or incorrect information to justify this, shows just how legally bankrupt this process is. Normal cities have established procedures for doing things. And Kalispell has established procedures for addressing problem properties. It didn't use those because this isn't a problem property. This is a political witch hunt. And as a matter of fact, Councilmember Gabriel, when she cast her vote against the warming center, said, "This is what my neighbors want. My neighbors elected me." That's not how you make decisions when you say that somebody has engaged in wrongdoing. That's not what judges do.
So this is a constitutional argument, which means if you prevail, if the warming center prevails, that's it for everybody.
I mean, we are looking to establish that certain rights and a certain process that didn't happen here and weren't respected here, the rights weren't respected and the process wasn't applied, that would go for everybody. I mean, this case is not just about the warming center. It is a case about vindicating the warming center's rights, but it's about ensuring that all property owners are entitled to a fair process when their property is being revoked or considered to be destroyed, and that certain rights are not subject to political whim when the winds change. I think it's important to note here that after the commissioners issued their letter in January of 2023, effectively pointing the finger at the warming center for causing homelessness issues in this community, the winds changed. And suddenly there was a hostility to the warming center. The prior year, when the warming center applied to increase its capacity for 10 beds, there was not a single public comment against the warming center increasing its capacity for 10 beds.
Right, and this is where the Constitution plays its critical role. The purpose of constitutional rights is to protect someone who might be politically unpopular, someone who is in the minority, someone who all of a sudden feels ganged up on by the political majority. And so that's why this is a quintessential constitutional case. It is a quintessential civil rights case because we are here to protect the rights of vulnerable people. And the political system has made them a target. And the U.S. Supreme Court says you can't do that.
So a lawsuit has been filed in federal court. You guys are ready to move forward. The question I have next is, what's in it for the warming center?
Yeah, so immediately with filing the lawsuit, we've asked a court to grant immediate relief, allowing the warming center to open. That's what's known as a TRO. And the idea would be that the warming center gets to open until the court gets to consider whether the warming center can open during the entirety of the lawsuit through what's known as a preliminary injunction. That's the immediate first step.
Yeah, and TRO is that means temporary restraining order. So basically we're saying to the court, hey, we need an emergency order right now to keep the doors open, to bridge the gap until you, the court, can hear a little bit more substantial presentation, maybe in a few weeks or a couple of months, and then make a decision about whether the warming center should be allowed to stay open for the life of the case.
How long will it be before you think the case actually gets to court?
Well, hopefully the court responds to our request for that preliminary immediate relief under the TRO this week or next. And then from there, Jeff's point about it could take a couple of weeks or it could take a couple of months for the second round of preliminary injunction relief, whether the warming center gets to stay open the entirety of the lawsuit. And then in terms of how long the lawsuit will take, that can take months, it can take years, and the Institute for Justice and the warming center are prepared to go all the way.
Yep. And, one of the interesting things about this case, because we're asking for so much up front, we're doing something unusual, which is we have filed a complaint that is over 100 pages long, that is full of evidence. And I think we filed over 50 exhibits, including affidavits with the testimony of homeless people themselves, people who work at the warming center, the board members of the warming center, doctors, social workers that talk about the real world consequences. All of that is going to be on our website at ij.org. So if people want to know what the real facts are in the case, they should go to our website and they'll be able to dig into the evidence and see what didn't come out during the kind of sham process the city put the warming center through.
I think one thing to add to that is that the city council made a big deal about police call data in deciding to revoke the permit. And in our complaint and in one of our motions, we look at that data and we break it down by month, per month, because what was being compared was not apples to apples. So we're going to look at that data per month and we're going to compare it to other nonprofits providing similar services in the area. And when you look at that, the warming center is not causing any, or not correlated with, because it's not causation, it is not correlated with any increase in calls compared to other similar folks. In fact, similar folks who are nonprofits in the area actually have more calls in their areas on a per month basis when they're open.
So the relief you're seeking, first of all, is to keep the warming center open and keep it open at least until the court makes a final decision, which could be months, years.
That's correct.
Right.
Okay. In the interim, things just go on as normal?
That's what we hope. If we get the order from the court, what we're asking the court to do is to say, let's turn back the clock to the day before the conditional use permit was revoked. Let's say September 15th, they had their permit, they just get to open, and it's going to be business as usual at the warming center until the court can make a final decision.
Are you asking for any other relief for the warming center?
Sure, we are asking for damages. So in revoking the permit, the city violated the warming center's rights, and there's been a damage cost to that. We are asking the court to determine that amount of damages, but ultimately we think the city should be on the hook for the financial harms and the other harms that it has caused the warming center.
I mean, they've lost out on donations. It costs money to keep a small nonprofit going, and so the things that they have lost out on because of the city's unconstitutional actions, they should have to pay for. It's common sense.
Curiosity is getting the best of me here. You guys are representing the warming center for free.
Yes, sir.
Your work is not cheap.
Yes, sir.
Who's paying you?
We fortunately are supported by donations and a phenomenal organization. We're a nonprofit, so donations are really the way that we keep the lights on and pay our salaries and take care of our families.
Yeah, people from all over across the United States. We don't take any money from the government. We don't take any money from corporations because what we do is we sue the government, and it's very often the case that there are powerful interests that are aligned with the government. And so just ordinary Americans, people who are generous, who want to support our work, support us.
So it's a nonprofit supporting a nonprofit.
That's exactly right.
Yep.
So what's your estimation of the outcome of this?
I mean, our hope here is that the court recognizes that the city of Kalispell violated the warming center's due process and equal protection rights under the Constitution of the United States, as well as the Constitution of Montana, and says that the revocation is invalid, and then awards the warming center damages for its loss of donations and other injuries.
Yeah, and I think the bigger picture here, one of the reasons why the Institute for Justice is involved, is that we're trying to create legal precedent that protects property owners across the United States who want to provide alternative or cheaper, lower income housing. And zoning codes and zoning enforcement people are notorious for using their zoning laws to screen people out by income. And so the reason why we're here at IJ is to create that kind of precedent so people across the United States who want to open warming centers, who want to do homeless shelters, who want to do low-income housing, tiny homes, just anything that's an alternative, that they'll have some rights to be able to do those things.
Well, this is going to be interesting to watch. I've been watching this, of course, from the very beginning, and we're just going to have to sit and wait it out. But obviously, the warming center is in good hands here.
Yes,
That's
and
right.
we'll be delighted to come back on and give your listeners updates as the case progresses.
We'll appreciate that. The Institute for Justice, Christie Hebert and Jeff Rowes. Guys, thank you so much for spending time with us and getting into depth with us here.
Thanks so much, John.
Thank you.